Is a non-compete agreement considered a legal document? In recent news, many workers are questioning the legitimacy of non-compete agreements. This topic has gained traction as employees seek clarity on their rights. So, is a non-compete agreement considered a legal document? Let's break it down. Yes, a non-compete agreement is indeed a legal document. It serves as a contract between an employer and an employee. This contract restricts the employee from working for competitors or starting a competing business after leaving the employer. The restrictions usually apply for a specific period and within a defined geographic area. These agreements are enforceable under labor and employment law, but they must meet certain legal requirements. For a non-compete agreement to be valid, it must be clearly stated in writing. Recent reforms in Texas provide a perfect example, especially for healthcare workers. The new law limits the duration of these agreements to a maximum of 1 year. It also restricts the geographic scope to a 5-mile radius and includes buyout provisions to ensure fairness. When courts evaluate non-compete agreements, they consider several factors. They assess the reasonableness of the scope, duration, and geographic area. Additionally, they determine whether these agreements protect legitimate business interests without unduly limiting an employee's right to work. Legal challenges often arise when agreements are overly broad or lack proper notice. Enforcement of these agreements depends on judicial review. Courts weigh the employer's interests, such as protecting trade secrets or customer relationships, against the employee's right to employment. If an agreement is found to be too restrictive, it may not hold up in court. In summary, non-compete agreements are legally binding documents. However, they must comply with specific statutory and judicial standards to be enforceable. Recent legislative changes, like those in Texas, highlight the evolving legal framework for these agreements. As workers navigate their employment contracts, understanding the nature of non-compete agreements becomes increasingly important.